Coming to you live tonight. I know, surprise. That's like 2 days this week, right? What's today? Tuesday. Don't forget you T-Mobile members. Be sure to get your perks from T-Mobile. Anywho, I was sitting at work today and per usual doom scrolling, and I've been wanting to do videos like this for a while, and this one is by no means going to be like professional, but I wanted to briefly touch on something, and if it can help somebody, especially help these people fighting in the comments that do not understand how trust and estates work. Um, because I was deeply disturbed by some of the commentary. And like I was telling my friends, I said, "Hello, everyone. Hello, hello." Good. Somebody said, "Good morning. You must be on the other side of the world." Um, I was telling someone, I said, I get it. Not everyone is versed in trusted estates. I've been doing it for 19 years in the private wealth space, and I do not always know everything. I sometimes have to go and research and, do whatever to find the answers I need, especially because of the jurisdiction I currently work in, which, by the way, is very favorable for people who like privacy. Okay. It gets a little complicated. Lord, Jada. Oh, girl, I didn't know. Okay, hey, Kizzy. Y'all, my sister on here. Anyway, I realized people don't know. And I saw Malcolm Jamal Warner's headline today where his wife is attempting to sue the trustee of his family trust that was established, my God, back in 1996 when the estate tax exemption amount was $600,000. Jesus, do you know what it is today for an individual? I think it's like 19 million right now. Your estate can have what they call generation skipping tax exempt, basically, as long as you declare it in your estate. So they see, I'm throwing out stuff already. And then there was Harold's Chicken. I don't know. I've never eaten there. I thought there was one still here in Henderson because the building is still up, but it said it's permanently closed. So there ain't nobody come and take away any of the stickers or anything. I said I wanted a good lemon pepper wing, but they don't have it. But the granddaughter of the founder died. Suddenly, I don't think they've disclosed, and that's disturbing because you've got the husband fighting the children. Now, I don't know if these children are a product of a prior relationship. To me, it doesn't sound like they're his children. I can't figure it out. And I also realize that some of my clients that I deal with on a daily basis do not understand how trusts work. And I also know that some of them may actually understand, they just choose to fight for the answers that they want, possibly coupled with some mental illness, but that's a story for another time. Because I've never seen anything like it. So, last will and testament. Most people will have a will. Most, uh, and then some people will set up a trust. And what I can tell you, and I am in no way, a licensed practicing attorney, but what I am is someone who has spent 19 years administering, interpreting, uh, you know, and when I say interpreting, that means drafting it in layman's terms for clients who sometimes um, may have just, who, I don't know why Cayenne 97 keeps typing 6 7. I don't know what that means. So we're going to remove, and we're going to, I don't know what that is. I don't know what that is. Like, does anybody know what that means? Like when someone comes in and constantly types. It's an unfunny joke. What is that? Block it. I'm trying to figure because usually I can block them. Okay, there we go. They're gone. Um. Oh, they said I'm sorry, but it's too late now because I already removed you from my channel. Um. So wills, you can have a last will and testament. You have a trust agreement. Um, some people die without that. As you know, one of my favorite artists of all time, Prince, died without any type of estate plan in place, which means that thus you leave it up to the state to determine what's going to happen to all of your assets, your proceeds, everything you've accumulated in life. And at this point, honestly, what do you care? Because you're deceased. However, what it does is cause a lot of conflict, and we don't need that. You're still going to have conflict regardless, because I can tell you right now, as soon as somebody die and people find out that there's money available, they're like sharks in the water. I'm on the committee that approves new business at my job. And when I say new business, whether we're going to take on and be your successor trustee or trustee for whatever reason. And, um, you know, they looked at me crazy when I first started. And I said, hey, there's a provision here that says in this trust that I have purposely not provided for X because I have provided for them outside of the trust. Now, when I see that, I immediately say, well, what have they provided? Because 9 times out of 10, little Sally Lou is going to pop up and she going to want to get paid or he's going to want to get paid. Twice this has happened. Twice I was looked at crazy in some respects, not by all parties, but some. And come to find out, somebody then lawyered up and said, I'm supposed to get something from the trust. Now, first of all, I don't know why a grandchild would think that they're supposed to get something when the father is still alive, but okay. Because normally it's a succession. Normally, when you have trust established, the grantor, normally they're revocable. What is a revocable trust? That just means that at any time you can amend, restate, revoke, do whatever you want to do to a trust. And people, please, please, if you have to amend your trust every year, please do a restatement. I kid you not. When I used to do trust pre-acceptance, I sometimes would get trusts that would have 25 amendments. I have to go through all of them and figure out what provisions no longer I'm going through Xing, just physically Xing stuff, only to end up with if you would just restate it. And yes, the restatement is more expensive because that's why they nickel and dime. I just want to amend this provision right here. Yeah, yeah, yeah. Oh, I want to take somebody out. I don't want this person in here anymore. So please, if you're doing that, just know you're not making it easy for your trustee or whomever. Um, but revocable, you can do it whatever you want to, but at death, that trust becomes irrevocable. And 9 times out of 10, there's going to be what we call an administrative period. That means that your trustee is going to order a whole new EIN because you likely were using your social security because it is being reported on your 1040 and not on the 1041, even though it is an entity. Um, and we're going to order an EIN and then we're going to marshal in all the assets that are either in the name of the trust or if you were really, really savvy and had a great attorney, you have a pour over will. That means that when you died, you before you died, you anticipate, I'm not going to remember all these assets. I'm not going to rename everything or do a pay on death to the trust. So whatever is outside, we'll probate it or do a small estate affidavit depending on the size. I think a small estate affidavit, like for instance in California, I think 25,000. If your estate is less, if your probated materials or assets are less than 25,000, we'll just file a small estate affidavit. So you're going to pour it over. So once everything's finished marshalling in, the whole point of having a trust is to keep it out of the public eye. Unfortunately, what is happening, and I don't know what is in this 134-page petition that Dr. Tanisha Warner has filed against Malcolm Jamal Warner's mother as trustee of his family trust. But what we do know is I'm pretty sure one of the exhibits is the prenup. I would be curious to see what that is. I was hoping someone had downloaded and put it online because DeKalb County uh, wants to charge 50 cents a page. I think it was 64, $67 to get a copy of this petition. She filed in DeKalb County, Georgia. She also filed in LA County. I don't know. I guess they were married in California. I don't know where they were married. Um, Likely California because California has it where if you do get married, we you can have your record sealed, but no one knows you're married. That's why when Richard Pryor died, no one knew that he was married to that gold digger. Let me digress. Uh, so anyway, let's talk about this case real quick. So, as I was trying to explain to people in comment sections, particularly in the Jasmine brand, the reason why Malcolm Jamal's Warner mother is not being difficult or mean is because, as trustee, she has a fiduciary obligation to uh, follow the terms of the trust. Okay. This trust was made in 1996. It does not appear that there were ever any amendments, restatements, or anything done to update it. It is shocking and surprising that he did not. But unfortunately, when you're 54 years old, you're probably not thinking, oh, I'm going to die in Costa Rica, just floating. But the riptides got him, and Malcolm is no longer with us. But for the life of me, I really wish he had updated his estate plan. When you got married, there should have been something done. As a matter of fact, the life insurance policy should have been taken out right away. Uh, let me let me go to this article where she talks about what it that that she wants because People Magazine has People Magazine. So now she's not suing his mother; she's suing the trust. Okay, so she's suing the trustee as trustee of the Malcolm Jamal Warner Family Trust. Um, in court documents found both in LA and DeKalb County on the 17th, uh, she claims she is owed $1,276,042.46. What is this comprised of? 1 million in the life insurance policy, $50,542.46 for an anniversary payment obligation laid out in their prenup, 30,500 with respect to a Roth IRA obligation. Every year he was supposed to put money into a Roth IRA, I guess for her benefit, and he did not do that. And she says that she served as chief of staff, I guess, handling the day to day administrative task of a celebrity. How is it that you allowed him not to pay you is beyond me, but I guess y'all were married, having a good time, and he was paying for everything. So you weren't really worried about getting paid. And for the record, y'all, she's not a gold digger. A premarital agreement does not cease at the time of death. However, it will become a creditor of his estate. And what she is saying is that she does not believe that estate proceeds will be enough to substantiate her claim. And I'm like, that's likely true, but that's true for a lot of creditors. Uh, Creditors often will have to take a settled amount. We will have to do, that's why they do an announcement to let people know, hey, so and so died. So if they owe you some money, you might want to come get it. They do it in the newspaper, publish it, wherever. Um, and now she's trying to reach into the trust. Now, one of the phrases that pays is spendthrift clause. Why do you want to have a spendthrift clause in your trust? That is so it will keep people from, number one, tying the trust assets to things that you really shouldn't be doing, like using it to secure a loan. If you were engaged in certain uh, things that only those of a questionable nature would be into. Um, your parents probably said we don't want that to happen, so yeah, you know. So basically, it insulates the trust. And here in Nevada, we get a lot of people that do asset protection trust. Now we do have the shortest vesting period, and it's 2 years. It vests. You can also check out places like Delaware, South Dakota, and Wyoming who have 4-year vesting time. So any of that money, like for instance, if you are trying to escape legal obligations when you establish a trust, within those 2 years, anyone can come and take, or within those 4 years, anyone can come and take that you're obligated to. Um, but if it's vested after 2 years, then there's really nothing that can be done. Your assets are protected. Now, once we make a distribution to you, that's fair game for your creditors as well. What I don't understand and don't know is who is the beneficiaries of this trust, because it says it's the Malcolm Jamal Warner Family Trust. A lot of times when people establish trust, they will be preemptive, especially when it comes to legacy and dynasty trust. They will prepare for a family to come. They will say things like, this trust is to benefit my spouse and descendants, but in the event that I should die without a spouse or descendants, then this trust will go out to whomever they may name. By the way, sidebar, I don't know what kind of friends I got, but I need to find some friends like some of these people got this open these trusts. Y'all opened a trust recently with a dude that the white husband and wife that opened a trust for their friend and his children. I was like, where are my friends at like that? Where are my friends? I need somebody to set me up a trust so I can get discretionary distributions for my health, education, maintenance, and support. That's another thing you'll see a lot of in trust. Hymns provisions, a legal fiction. Really people purposely put hymns in so it's an ascertainable standard, because sometimes people will allow their individual who is not only a beneficiary to serve as a co-trustee or a trustee. And if they are a trustee and a beneficiary, they can only make distributions for the benefit of their health, education, maintenance, and support. Now, maintenance and support can run the gamut, but it has to be all within reason. Okay. Oh, thank you. Oh, my little brother's on here. I'm sorry, y'all. My earbuds are falling out. So, let's. Oh Lord. What's going on? Hold on, just a second, y'all. Hold on. All right. Let me know if y'all can hear me. Let me know if you can hear me, because I don't know what just happened. My earbud decided it wanted to start playing Coltrane. Can you hear me? John, can you hear me? Mm, I don't know. Let me see. Can you hear me? Okay. Okay, good, good, good. I wasn't sure. Okay. So I forgot where I was. But either way, yeah, ascertainable standards. So sometimes you want to have that in your trust as well. But in order to establish a trust, you just need to have a grantor, a trustee, state what your intention is, the purpose of the trust, whatever, uh, and property, what property you're going to put in there. And beneficiaries. It can be charitable. You can leave your money to charities. By the way, I often do wonder how some of these people die without family. Yes, John, we need to get some trust love. I don't understand. I remember it was some old man who was never married and never had children and left everything to charity. I was like, damn, should have befriended him. Maybe I could at least gotten a third.
or a fourth of some of the estate. But no. But trust also 9 times out of 10, unless there's something funky going on. For instance, if someone was sick at the time that they made adjustments to their estate, and you question their capacity, um, yeah. But 9 times out of 10, it's hard to overcome that, especially when you have an attorney witnessing it. Because in the minds of the courts, their whole thing is what attorney in their right mind would risk their law license by lying and saying, oh no, they were perfectly sane. They were perfectly fine when they signed. Because of course, they're going to say they're perfectly fine. Why would they admit? Remember Trim Spa Baby, Anna Nicole Smith? Yep, that I don't remember the details of that one, but that one was really sad. But then when it comes to wills, uh, hey, it's going to end up going through the public courts. There's not a lot you can do to seal it, although I see some of these jurisdictions don't just allow you to go in and download stuff for free. They have paywalls now. Um, but a will, yeah, that's a great way to parse up your remaining assets and tangible and intangible goods. Okay, uh, you know, but be as specific as possible in either document. Because the last thing we want is for somebody to be out here in the parking lot fighting over daddy's Cadillac. Okay, we don't need that. Okay. Um, but a will goes through the public eye and is probated. And that is a way for creditors to get what they are owed or a piece of what they're owed. And that's how I see what's going to happen with Dr. Warner. People are vilifying his mom. I'm like, she's a trustee. We have a fiduciary duty to follow the trust. We do not want to breach that fiduciary duty. And we want to honor whatever it is that the grantor wanted. Um, and then we want to be able to pour the proceeds of the estate into your trust. So you want to have a pourable will. And that's pretty much what's going on. I'm very interested to see how this will play out. While the prenup does uh, state that it is his intent at the time of its making, it does not reference a trust, apparently. Now, if it references that in the event of his passing that she can take from the trust, that's different, but we don't know. I show the hell hope TMZ publishes because I want to go through. I love reading stuff. I do. I love reading the trust. Um, but I was on Jasmine Brand. She said he failed to honor his prenup. I wouldn't say he failed to honor the prenup. I would just say he died. Because, I mean, it sounds very harsh to say that when the man is in the grave and can't do nothing for you. Okay. Um, let's see. So I was reading it. Has filed a lawsuit against his mother, Pamela Warner, who oversees the Warner Family Trust as trustee. Okay. And so I made the comment. I'm read y'all what happened in the comment section of Jasmine Brand. I said, ma'am, the trust is likely fully vested and there is likely a spendthrift clause in it for asset protection purposes, including, the Seymour don't work on. Okay, here we go. Including lawsuits. The trustee does not have to pay you. The trustee doesn't have to pay you, but you may end up having to pay the trust back. You may have to pay the cost of litigation. And now you're just digging yourself in a hole. And I hope her attorneys told her that in anticipation for litigation. Then we have someone named Enrique Vasquez come on. And bless his heart, sugars, bless his heart. He says any good attorney knows that a prenup supersedes any will. Death does not void a contract, sweetheart. That's what he said. He called me sweetheart. If there are obligations in the prenup that he agreed to, the trust needs to pay up to abide by the terms of that contract, the prenup. Death does not clear a contract. That's Contracts 101. The clapback. Uh, I said, well, Enrique, good thing I do this for a living. And guess what? I have a law degree. I have a Juris Doctor. Okay. Um, oh, I said I have a law degree too, sugar. Okay, since he wants to take it there, I can't stand when people do that. You don't know me from a can of paint. I don't know you either. Um, I said anything outside the trust, his estate, she can recoup on the prenup terms. But trusts are harder to penetrate, and the whole point of having a trust is to maintain privacy and not to have it in court. It also depends on the governing law of the trust. For instance, even if this does end up getting litigated in court, here, if it was here, if he had Nevada as the governing law, we could automatically at filing have the record sealed to keep it out of the public eye. Okay. Um, Somebody said that's a will that can be probated, sweetheart. A trust cannot, especially an irrevocable trust with a generational trust attorney. Uh, Somebody told him he don't have to be passive aggressive. Uh, and then I went to his page and I went to see this baby, bless his heart, and I'm gonna share this with y'all too. So I Well, first of all, let me just say he's studying for the LSAT, and the LSAT is the graduate exam you take in order to have a law schools evaluate whether they're going to accept you based upon your score. Okay. So I advised him, I said, and Enrique, when you do get to law school and you get in your second or third year of law school, 1L year, you have to do all the basics. But your second year and your third year, you can take whatever you like, pretty much. And I encouraged him to take decedents, estates, and trust. Now, I was laughing when he said this because I remember I worked for a large law firm, at that time it was the largest firm in the world, I believe. It had 27 offices worldwide. And I worked in the Dallas office. And I remember I learned certain terms. And I was so excited when I got to law school, I'm going to use them. And you remember the Chris Rock joke where every answer was Martin Luther King, Martina Luther King? Yeah, that was me the first day when I felt like I knew the answer to a question in civil procedure. And I said, is it a motion in limine? That was my phrase that pays. Okay, motion in limine. Um, so yeah. So I can understand why he doesn't understand the difference between how a will works and how a trust works. A lot of people don't. They just don't know. Molly Tarala, thank you very much. Um, so y'all, when it comes to estate planning, please, first of all, I'm just glad the brother had an estate plan in place because some of these celebrities die and their stuff is just left for the wolves. Okay, Prince especially should have had something in place because he had his sister, what was her name, Tika, who kind of was trying to um, take care of everything, but unfortunately she died suddenly in the midst of this. And he has all these other half siblings, I guess from his dad's side of the family or something. And so he had no estate plan. Okay? I was like, damn, he had no holographic will. What's a holographic will? Handwritten will. Something. Um, so again, this is not going to be the intellectual right. This is just me kind of off the top of my head recalling everything in the scenarios. Now, recently, Harold's Chicken was in the news because the founder's granddaughter passed away and the business is in limbo. And this is shocking to me because why? It is incorporated, which means it should have articles of incorporation and, most importantly, bylaws. It should have a board in place. Now, how Harold's Chicken, I've learned, operates, thank you, Molly. Now, how Harold's Chicken operates, from my understanding, is that the corporate office is set in Chicago, but they also have a franchising in, they have a trademark, thing going on. So it's very interconnected. But if you have a board, shouldn't the board already know a succession plan? And even if there's not a succession plan, they should meet and vote on who the next CEO is going to be. The other arguments that have come up is that there is a will, there isn't a will. The husband says that she purposely intended to die intestate. And intestate means to die without a will. Okay? If you die testate, that means you have a will. Okay? I said, that sounds crazy. I don't know if this is their father or if this is a second, third marriage. I don't know. All I know is that it's weird as hell to me that there is even a dispute. Now, if you're talking about inheriting mama's stuff, her good dress, her furs, her jewelry, and all of that, that's a different story. Plus, if she's married, here's what happens a lot of times with second marriages. If this is a second marriage, I don't know. I still haven't figured that part out. What you want to do when there is a blended family situation, you want to have that second spouse have a Q-tip. And if that's a spouse that's like a foreign spouse, it's not a U.S. citizen, you want to have a Q-dot. Qualified, terminable, I forgot what it's called. I can't remember. Anyway, it's a spousal trust. It's a marital trust. And a lot of times with Q-tips, the spouse can only take net income. They'll get they're entitled to net income. And sometimes that's all they're going to get, net income, based upon whatever the value of the trust is. And let me tell you, if your trust is worth a lot of money, and if you get a good investment person, hey, you can live off the net income. Now, some of y'all be having these small trusts, and we end up having to convert them into what we call CRUTs, converted unit trust, and because we got to help them out. And what we do with converted unit trust, or even with unit trust, period, is that we'll look back the past 3 years and give you the average and parcel it out at a fixed amount once we do a calculation. Also, some people will have IRAs established, and the IRS now wants their money sooner than later. So if you get an inherited IRA, thanks to the SAVE Act, no, the Secure Act, I'm thinking the Secure Act, you better spend that down in 10 years. And you can have that paid to the trust, but the trust pretty much becomes a pass-through. So like right now, I have a relationship where I will have the money moved from the brokerage to the trust, and then I will disperse out the proceeds of the RMD, the required minimum distribution, to whomever the beneficiary is of that trust. Some you can just leave it in trust once it's dispersed from the IRA, but for the most part, most people will have it set up where it just passes through the trust. Okay. But with Harold's Chicken, I really need for them to follow whatever the guidelines are. I really need more details on that one, to go take a deeper dive. But usually people have a pretty good succession plan in place for business. Like, at least if you got a board, you can vote. Everybody can vote. So I'm trying to figure out what's going on with the corporate structure there. But if there are any questions about trust and estates, the big key thing with them is have one. Have a will, have a trust, but it's best to have both. Where is your best asset protection? Delaware, South Dakota, Nevada, and possibly even Wyoming. I've got to research the state of Wyoming. The good thing about Wyoming is this: if you register your business, an LLC, LP, whatever it is, in there, you don't have to disclose who the members are and who the managers are. Secret? No. The trust component, that's a different story. But Nevada Trust, I will say this, the problem with Nevada Trust, when dealing with California, California is very greedy, but I also get why they're greedy. After having lived there, and the employer ended up having to take a leave of absence, and the what was it, Liberty Mutual, I think it was the short term disability insurance wouldn't approve me. I'm like, I'm on the verge of a nervous breakdown. My blood pressure is on 10. What the hell? State of California paid me more than I got paid working while I was out on disability. So, yeah, it's expensive to live there, but if your life should end up coming completely undone, the state of California is there to support you economically and financially. And I can tell you, after being unemployed in the state of Nevada, they do not charge state tax, but I still feel as though they should be able to, for all these damn casinos, the gaming commission alone, okay? But either way, California, the what is it called? The tax board, the FTB. Them mofos don't care if you owe them a dime; they want it. You're always going to have to pay taxes or do some sort of California withholding on your taxes if you are a resident of California, you have real estate in California, even if your trust is in a different jurisdiction. You won't pay taxes in the state of South Dakota or Nevada, and I don't think Delaware either, but you will pay taxes. We will have to pay taxes in California for the trust, and you also may have to pay taxes. So just always remember that. But the key component is if you do decide to establish a trust in these jurisdictions that are more favorable than others, that trustee must set in that state. You do not want a California trustee. That opens up a whole other gate for taxes for the FTB. Um, I'm trying to think what else. And you can have what's it called? You can have an irrevocable trust that is called an intentional defective grantor trust. And usually that's because grantors will reserve the right to substitute property in a non fiduciary manner. And that too, we will order an EIN for, although you will still get a grantor tax letter because it's the income and distributions are reported to your personal income tax until you die. Another thing that Malcolm Jamal Warner, I just thought about, could have done, he could have done an ILIT, which is an irrevocable life insurance trust, where he placed a policy in place, and upon death, the proceeds of that policy would pay out to the trust. And either it remained in trust or it distributed outright. And that's the other thing I'm curious about. When you say it's the Malcolm Jamal Warner Trust, did you only provide for your parents? And I don't know if he had any siblings. I think he was an only child. I think he's an only child. Um, I don't know what all it has, and I don't know if he had a provision for in the event that he ever had children. I sometimes wonder with Malcolm Jamal Warner if he ever really wanted to have children. I know that him and Regina King were in a relationship for a long time. Matter of fact, they joined my church when I used to live in California. Um, but I don't know if he ever intended to have children. I know he wasn't big on marriage. He never wanted to be married until he met this woman who people, are vilifying her and vilifying the mom. And I just want to encourage people not to do that because I get it. A lot of people don't understand how trust and estates work, and they don't understand how a trust works versus what a will is or even a probate. But as of right now, what I can tell you is that his widow is a creditor of his estate, not his trust. I I really don't foresee, unless I will say this. Now, if there is a provision that allows for the trustee to petition the courts to modify the trust without making a material change, maybe she can get something that way. I don't know. Like I said, I don't have a copy of the trust. I don't have a copy of the premarital agreement, but I really, really wish that what Malcolm had done, and I know because even myself, I'm sitting here at 49, and could drop dead tomorrow, next week, a year from now. You just never know. But we need to have something in place, something. Even if ain't nothing but you have written out what you want to happen on a piece of paper and signed and dated, holographic. Do something. These days, you can pretty much. I do encourage y'all to stay away from Chat GPT. Don't let it draft you, will. But Copilot and Gemini, I do use, and I do find them to be very useful. I also vet all my sources to make sure that they are what they are. But again, remember, by my very nature, I am a researcher. Even before law school, I loved writing research papers. And I used to get paid at one point. One of my jobs in undergrad, I used to go, I had a nurse that I worked for that was working on her doctorate, and I would go to the library and look up all the documentation she needed. And, but anyways, I've gone on too long. Uh, Please comment down below. Let me know if you have any questions. Again, remember, I am not a licensed attorney, but I am a trust officer that has been doing this for, as a matter of fact, right now I'm a senior trust officer, and I have been doing this for 19 years. And I have, so yeah, in addition to being a comedian and commentator, I actually do stuff, corporate wise too. Eventually I will get back up on stage, but not too soon. Uh, but I'm gonna pray for these people because y'all need to stop fighting every time. Oh, wait a minute, one more thing is one of my clients. So I don't know why she thinks this, but so anyways, that's a when you have a revocable trust. Stop, Ava. Go. You are not getting any more treats. Y'all want to see something? This little animal. This little animal here. She's not little. People always say she's not. She wants attention. Hold on. Look. Lady Ava. Lady Ava. Oh, she been eating. Did you eat, Mama? Look. She running with a ah! Ava, wait. Stay. Stay. So, um, when we call things a subtrust, or when we call them follow through trusts. So, after the administrative period, when an irrevocable trust becomes irrevocable and we marshal in all the assets that are named in the trust or poured over from the will, we split it out per the terms of the trust. A lot of times you will have a family trust, aka a credit shelter trust, or you will have what's the other things that they call? And then they'll split it up: GST exempt and non-GST exempt. If it's GST exempt, that means skip persons can take from it. Non-GST exempt, if you're not a skip person, we encourage you to take from that trust first, exhaust it, and then go to the exempt, because 9 times out of 10, if the estate plan is split that way. Those are follow through trust or subtrust. It does not mean that we gave you or drafted a new trust. Because one of my clients actually asked me that, but I didn't answer because by that time I had told her she needs to consult with her attorney, because I have attempted to answer questions in the past, and she would tell me no, even though I knew what I was saying was right. Like, to this day, a trustee report, if you see anything that says a trustee report, that means a customer statement or a statement of your account, which we mail to our clients every month or quarter or annually, however they want it. Or if they don't want to get paper statements, they can log on and look at their statements every month or every day just to see what's going on. And so I just wanted to explain that too. So if you ever hear a trustee say, we're opening these new accounts or these new trusts, it's not because we've drafted a new document. We can't do that. Now, what we can do after you die is decant, okay? And when you decant, you cannot add parties, but you can take away certain parties. And we've had to do that because of jurisdictional issues that go on. I think by far the craziest decanting an old trust from one jurisdiction to our jurisdiction to another trust to split it for two different beneficiaries. And I'm like, y'all could have just done that in one swoop. I'm just saying. You could have kept it as a pot trust, accumulating pot trust. Look up the Oppenheimer Family Trust. That's a great definition of an accumulating pot trust. Okay, but that's it. That's it. I'm gonna get off. Y'all comment down below. Let me know if you have any other questions regarding trust in the estate and understanding revocable versus irrevocable and all the other asset protections that you can do if you establish a trust. And even if you're still alive, it can be irrevocable, but it can still be looked at as a grantor trust because you're substituting property in a non-fiduciary way. And you can also serve as trustee of your own trust. But 9 times out of 10, you're not going to serve as a distribution person because that would look like double tipping. By the way, if anyone needs a trust protector, I'm available. I want to get paid every quarter. No, anyways, I'll talk to you later. Y'all make it a great night. I've been Miss Sophia the Diva. Let's get our estate plans together, guys, okay?